that is the shown arrest matter. Now, your lordship fixed it on 7/4 on Monday, my lord. But then the e-court, my lord, system, it has been shown at 7/5/2025. So, my lord, if your lordship call for the record and correct that.
Order to 7/5 for us.
Yesterday, item 6.
Who typed this order?
Yesterday, my learned colleague.
Yes, I can.
6 yesterday.
Yesterday's item 6.
Two items were there with
Two
you,
items,
I believe.
yes.
In
Both-
one of the matter, the next date has been wrongly updated as 7/5.
And one in other one?
That one is okay.
8/4.
It's okay.
That one is it.
Okay, we'll see to it.
Mine.
7/5 for us. Huh? Okay, yes.
I just put it for Urdu and on Monday.
Problem.
In item number 30, we can find an additional evidence yesterday. For record may be called for.
No, we are not going to sit up to 12. I'm writing. It's not
Yesterday,
been with. I want to, next, I mean, second half, I'm not going to sit.
no problem.
If it comes, then it's okay, otherwise, no.
If it comes, maybe deeply updated.
May I please, your lordship? Your lordship, I would to mention item number 17 of today's daily mail. In this case, your lordship, by order dated 4/3/25, your lordship, up to dated case diary was called for.
Up to date case, there is not received. CD received, it's not up to date.
Not up to
Not
date.
up to date.
Are you on interim there?
No, your lordship. It's a POCSO matter, your lordship.
Not on interim.
And one more prayer, your lordship. In this matter, your lordship, by office note dated 11/3/25, your lordship, the report was submitted by the police that they have received the step, your lordship, after the date. So you may be allowed to take step upon the
After?
after the date of on which the case was listed. So they could not take this
14,
step.
17 of CD not received, issue reminder.
Up to date case.
Further, the updated case diary, CD, updated one is not received, no?
No.
Updated case diary is not received, issue reminder. Calling for the updated one. Further, the petitioner side is hereby asked to take steps on the respond number 3 to jurisdiction police station, put it to the office of the registrar and the public prosecutor. Yes, when it
On
can be
23rd.
23rd.
Oblige, your lordship.
Release item 1.
May it please your lordship. My lord, the petitioner is just past class 12. He's of crossed 18 years of age, my lord. And he's in custody from last 22 days. And my lord, so far the allegations in the FIR is concerned, my lord. A boy his friend had a relationship with a girl, and the girl used to send her some private pictures to his boyfriend. Then what they did, that boyfriend created a telegram group along with this petitioner. And that picture, some of the friends have paid money in the father's account of this boy. And he has given the father's account number in the telegram group. And that's why police have arrested him. So far investigation part is concerned, my lord, there is nothing to be recovered from this boy. And everything has been seized and recovered. But admittedly, my lord, if your lordship looks into the order of the learned magistrate, it has rejected the bail petition. Your lordship will kindly look at page 31.
Yes.
The last line your lordship will see, the accused has been intimated about his ground of arrest through notice under section 48 of BNSS. My lord, that is fine. The IO could satisfactorily explain for not serving the notice under section 35(3) of the BNSS. 35(3) of the BNSS is the earlier 41A. So admittedly, my lord, there is no compliance of 41A. We have one of your lordship's judgment where lordship has elaborately dealt with section 41A. And my respectful submission is that, my lord, since he is a first-time offender with no criminal antecedent, and he is now waiting to get his admission in the degree examination, further custodial detention may not be necessary so far the investigation of his case. And since admittedly there is not non-compliance of 35(3) of the BNSS, At this stage, your lordship may
Now
consider.
see, there is an observation made by the learned judicial magistrate first class regarding though this notice was missed, but satisfactory explanation was there.
But
So that was considered.
yes,
So
but
that's
considered,
why-
but not rightly considered, because 41 is, your lordship will remember that certain, it's a mandatory provision. There, you cannot, the IO cannot say that I have an explanation for not complying with a mandatory provision, my lord. That is the
Yes.
incorrect application of law, my lord.
My lord, the rejection order reveals that, my lord, there are sufficient materials, my lord, against the, my lord, accused person, my lord. And regarding, my lord, 47 notice, my lord, that will reveal from the case diary, my lord.
35(3).
So let the case diary be called for, my lord.
No, notice 48, 47, 48 are complied with.
Yeah,
That is mentioned.
no, 35(3).
No, there are
35(3) is idea 41A.
35-3.
35, but we will peruse the case diary, my lord. Whether it was complied or not, my lord, that will reveal from the case diary.
The observation of the magistrate is very explicit. It says that it was not complied, but the IO gave an explanation, my lord.
Okay, we'll call for the case diary.
Yeah,
otherwise.
Then, my lord,
But-
may I pray, my lord? This boy is just waiting to get his admission in the degree, my lord, on Wednesday next, because it's a local police station, my lord.
No,
We'll
but-
try our luck, my lord. Let it,
No, I can't track my luck now. That is the problem.
my lord,
I was overburdened with all this. It's not possible.
but just any day before the vacation, my lord.
No
one.
vacation.
Others, my lord, so far, my lord, I respectfully pray, my lord, considering his age, just only 18. One any day before the vacation, subject to your lordship's convenience, my
We
lord.
don't have, that's right.
Otherwise, if it's a normal case, we'll have not prayed. Because keeping a young boy in the jail in this, this is not a reformative center there. A lot of people make mistakes in life, and considering his tender age only, I'm praying for, because Buban will be around 12 days. Otherwise, I would have not prayed, my lord. If it is a serious case, my lord, any day your lordship will kindly consider, my lord.
Itu matahari mai benda. Itu kami ni. Yeah. Right. Speak or good. 10.
We are blessed. Yes.
Item 2,
This is the lordship. The petitioner was arrested in this case on 18/3/2024. He is a auto driver by profession, my lord. And on the alleged day, my lord, while checking, my lord, while Naka checking, my lord, some contraband were recovered from passengers' belongings, my lord, handbag and other things. So thereafter, my lord, he was also arrested. And now, my lord, I'm pressing for my consideration of bail application on the ground of, my lord, page 41, lordship, may kindly have a look, my lord. I've also obtained the certified copies, madam. First. Perusal of your lordship, madam, page 41. Admittedly, madam, nothing was communicated or written in this notice, madam, carrying his arrest. May I just hand over, madam?
Your investigating authority is still doing these things. In spite of repeated this one. The message has already gone to even to Home Secretary Home also. Home Department.
Order passed, my lord, Bian Kumar came in the month of February, my lord. February.
The Praveen POCSO was earlier to that.
Procedural POCSO was, my lord, earlier to that, my lord.
Yes.
But this case was, my lord, of 28/5/2024.
20? No, 24 or 25.
28/5/2024. So,
It's
my
a case
lord,
of 24.
they are probably, my lord, they are not aware about the, my lord, what is, Garrison passed by the honorable elections.
And it's a such case, my lord. So, my lord, there are sufficient materials that my lord accused came to my lord know about his why he has been arrested because such a
So what to
submitted
do?
case.
These are not the now, obviously. Obviously, he knows. There is no dispute about it. Yes, right. Heard Mr. M. H. Choudhury, the learned counsel for the petition. Also heard Mr. I.J. Guru, so and so, this is an application, acceptance, so and so, in connection with so and so. It is submitted by Mr. Choudhury, the learned counsel for the petition, that the accused is innocent and nothing has been seized from the person of the present accused petition. So he got arrested in connection with this case on 28/3/2024. And since then he is behind the bar. Charles has framed no.
No, man, charge sheet and
And the two charges has already been made, but charge is yet to be framed in this case. Further, he submitted that there is total non-compliance at 47. And it was, I think, 50.
yes,
Fine.
Speaking of such matters, we are not aware.
So what is your information regarding any information?
my lord, regarding the progress of trial, I will just check my lord and update the lordship.
No, in this regard, what is your, whether CS has already been filed?
Yes, ma'am.
Charge
Yes,
sheet?
I have an next step. That I have an next, my lord, and certain witnesses are there, my
Okay,
lord.
then it is charged to court কাটি দিও। CS has already been made. আৰু বাকি এইটো সিহঁতে comply কৰিছে section 50, not 47. Section 50, তাতে ন arrest memo, inspection memo. The grounds are available now. আৰু বাকি submission of the Borwar sufficient matrix. And as charge sheet has already been laid, the accused is very well aware about the charges level against him. Commercial quantity is already. Okay. Under whose satisfaction?
Patient that telling you.
Karimganj jail khali ho jaye. Special just Karimganj. Okay. Deep.
Forward. I couldn't reach in time. I have made a mention to a matter to be listed on Monday.
You make a mention before court number 3.
3. Court number 3 will see that after writing of these.
No way.
Item 3.
You করে যাবো কিবা।
The petitioner is behind the bars for last 1 year, 3 months and 15 days in connection to NDPS case as a commercial quantity. So here
1 year?
1 year, 3 months, 15 days. Commercial quantity. Here also, I am a driver of a vehicle run under one transport company, that is Safe Express Private Limited. It's a Delhi-based company. And one entity called Bablani Brothers of Delhi book one consignment at Delhi itself for delivery at Tripura. Accordingly, the consignment was received at Delhi of Safe Express, and it was then on the way to Tripura, the vehicle was intercepted, and I was a driver. And the Bablani Brothers, this was being the employee of the driver of that transport company. I have no knowledge about what is the inside the packages. So because it is not only that consignment, there are many other articles, many other consignments also there. It's a 6-wheeler vehicle in the vehicle, and even I have annexed all the documents pertaining to that consignment. That Bablani Brothers who send the consignment, they submitted GST invoice. Everything is there. Even I would like to refer the that is Caesar list. It is clearly reflected. I would like to, for the satisfaction of this honor, I would read page number 22. This is the Caesar list. It's clearly reflected that GST invoice it was issued by Bablani Brothers. Page number 22.
22.
22 of my petition. Bablani Brothers, this was issued the GST invoice in the name of Surya Enterprise, and the product was they have named the product as compressor oil. So everything was there, even in the same page number 22. It is there as circumstances of the Caesar. It is clearly reflected in the Caesar itself that each bags are tagged with a white and green color tag of Safe Express. This was sealed and tagged. I was only the driver and it was intercepted.
Okay, then you were not aware of about the contraband.
Yes,
which was-
and moreover, the arrest memo that was served upon me that there is no ground of arrest. May I place the arrest notice under section 50 of the CRPC? Please only mention the case number and the section and only said that
No, this is how, it is not certified.
it was served to me. This is type copy. This is the original one is with-
Original one, you give me original one. How can we believe this?
the next page is the original one.
And next page,
Next page is first one is the type copy only.
next page is also not original.
This was the printout. And the
You
it was
bring, otherwise you give the certified copy or
Will be required for.
Yes,
it will require because we don't have anything now before us.
so already I have, the petitioner already applied for the certified copy. If this honorable court fixes short, small date, shorter date.
Short date we don't have. That's what I'm sorry. If you can place it down, just you can get it. Because we need something at least now.
Yes, maybe
be reviewed.
during the course of the day, if I
Second half we are not going to sit. I was division
no,
bench.
before the last item, before the license, before the
Is this to
before
do?
this honorable court rises.
Before one.
Um,
Before one if you
before
can.
one.
If you can. Otherwise, I'm not, second half we have a division bench.
One last ground.
No, grounds are okay. No, mainly your ground, this one is the your ground.
Yes. Yes.
And otherwise it will be fixed after view only.
I'm obliged.
Like it, for time being, we are keeping it.
I can go.
Case, what we see the Bharat case now in the top rate index on this. But. File also will find out. 15 lawsuits. No lawsuit, the allegation is there lawsuit. I think lawsuit will, they have to go to the case there, you know, because they have checked it for trade index lawsuit, they say the amount 10,000. But there is the explanation regarding the 10,000 lawsuit. The money receipts are there. So lawsuit.
If you calling for the case, let us see.
Can you prior to Bihu lawsuit? Absolutely.
No,
No,
we don't.
can we see?
Just don't give us, we don't have any dates. We don't have any date. After being corridor, 22nd. 22nd is also full of nothing. 24. Date we don't have. When he got arrested? When he got arrested?
Lawsuit, arrested on lawsuit, 26.
Insisting on.
Much obliged.
Item 5.
POCSO has been added in this case, Mr. We have made the informant party, Mr.
Huh? You have made the party.
No,
Notice is to respond number 2,
8th of February arrested.
February 8th,
He was
section
arrested.
6 POCSO.
My lord.
Yes, when it can be fixed.
Immediately after vacation.
Immediately after vacation will do, or you want any date fixed? Date, then it will be
22nd,
22nd is not possible.
23rd.
23rd, okay, bracket
My
23rd.
lord.
Issue notice corridor, call for the case. We call it.
Grateful.
Item 20.
Go to ground for the ban. Item 20. Item 20 is not there, I think.
20. Yes.
SR Ravan. You are on item 20?
My lord, this is supplementary.
Yes, sir, supplementary, item 20.
Yes, sir.
We are on item 20. Are you on item 20?
My lord, Ravindra Vishwas is.
Yes, yes,
Yes, ma'am.
Ravindra Vishwas.
Sorry, my lord.
Oh.
My lord, the petitioner, my lord,
Hmm.
is a 2 times member of the Bodoland Territorial Council Legislative Assembly, my lord. My lord, this is the case, my lord, absolutely framed, my lord. Because of some political reference. There was a Mela held, my lord, in Kauli area of Tamalpur district, my lord. And may I read the FIR, my lord, for page 8, my lord. I beg to state that yesterday, that is 29/3/2025, at around 10:30 p.m. As I went to Kauli Bazaar for attending the Barni Mela,
as I was called upon the stage for felicitation. And when I was descending from the stage after felicitation, the aforesaid accused abused me by using different filthy language, manhandled me, and attempted to shoot me with the pistol which he had carried along with him. Out of fear of life, I entered into the vehicle to and support, and then again he followed me and broke the rear glass of the vehicle. This is the allegation. Absolutely false, my lord. He was on the stage, my lord, and it was a place between some members of the two political groups, my lord. At
Maybe
this
your,
point, my lord,
schedule.
what I want is, my lord, kindly think the matter before me, my lord.
sorry,
Issue is, my lord,
extremely sorry,
one of the daughter, my lord,
extremely sorry,
has heart issues, my
extremely sorry, we are done. When he was got arrested,
lord. First of all,
first of
I
April,
helped
yeah,
with the same
extremely
case, my
sorry.
lord. I knew personally.
Pardon?
His daughter has heart issues, serious heart.
I'm personally,
Kindly,
I'm extreme-
11, my lord.
we don't have any dates. Repeatedly, I'm saying, we don't have any dates. After we humiliated 21 for 21. City Corporation. They are being so good, nothing.
Within 6.
Charge seated.
Yes.
Acha, he-
Showcase notice should go.
My lord, what happened in this case, my lord? They both major and they got married, my lord. That is, I have annexed, my lord. And the lady is, she was born, my lord, born to 18/4/2025, and they got married 25/6/23. At that time, she was 18 years, 2 months, 7 days. Annexer 2 birth certificate, my lord.
Any case.
And my lord, in this case, my lord, it is fixed in the law code, my lord, 16/5/2025. I may be allowed to appear before the court. Till then, I may be
16/5/25.
protected. Yes, my lord.
Have we annexed any order sheets here?
Yes, yes.
Where is the order sheets?
My last order I have not annexed. Earlier order I annexed. That is page 42. 43 also. Special case number 323/2000. Additional session just 41 page. So I may be allowed to appear, madam, then. Action will be given.
Your
And the
summons were issued or this?
Yes, someone was issued.
NVW is not yet issued.
It is fixed for appearance. And the date was fixed 16/5/2025. I may be allowed to appear before this honorable court.
Next date is 16/5.
16/5/2025.
It is obviously POCSO, Mr. Kaushik, but the charge seated one only. So we can protect him till he appears.
Yes.
That much only can be done.
And my second one is the father of the.
Yes, yes, obviously, there's no issue.
No, my
So
lord,
we are
what
not, we are
happened?
not finally going to
My
dispose
lord-
of the matter. In fact, the interim protection will be there and he will appear. That much only.
An affair was lost by unknown person, my lord. That is the reason. Neither neither the girl's father nor the someone, my lord. They do not know the person who has filed the affair. That is the interesting, my lord.
He is not related.
No, nothing, my lord. Both of them do not know, and then both
It is
were
also registered under child marriage.
because she is a mother, my lord. At the time of marriage, she was above 18 years old.
At the time of marriage, she was aware. Prior to that, was there any physical relationship? No.
No, no, no. It is a arranged marriage. And second one is the petitioner is the father of the accused number 1. Dildar. So I may be allowed to appear.
MSK Deputy Learned Counsel for the petition. And also heard Mr. R.R. Kaushik, the Learned Additional VP, appearing on behalf of state respondent. This is an application of the section so and so in connection with so and so. Next, right, is submitted by MSDB that the present accused petition number One is the husband of the victim and the petitioner number two is the father of the petitioner number one. The FIR was lodged by some unknown person and they are not at all related with neither with the victim nor with the accused persons. She further submitted that at the time of marriage, the girl was about 18 years of age and presently they are residing happily as a husband and wife. Child is there. You have any child?
No, no, no. He recently married.
This is so and so. They were also not aware about the lodging of the FIR. However, after receiving the summons from the court, both the accused petitioners were aware about the pendency of this case. They are ready and willing to cooperate. So they are ready and willing to appear before the learned trial court below and to contest the case on it. Contest the case if some interim protection is provided to both the petitioners. She also annexed the birth certificate and other marriage certificate, etc., along with the petition. Next, in this context, Mr. Kaushik, the learned additional PP, submitted that is the case under the POCSO Act, and hence the notice has to go to the respondents. And full stop, and more so, both the accused petitioners were shown as an absconder in the charge sheet. Next para, accordingly, he insisted to call for the case record and to issue notice to the respondent number two. Next para, considering the entire facts and circumstances of this case, the other annexures filed along with the petition, I find that both the accused petitioners may be directed to appear before the learned special judge. So and so learned special judge POCSO Dhubri. Learned special judge POCSO Dhubri in connection with special case number 323/2023. And with a regular bill application. And till when next date is 16/5.
16/5.
Till the application for regular bill on or before the next date of listing, that is on 16/5/2025. And the learned special judge will consider the bail application in accordance with law. Till 16/5/2025, the petitioner will be under interim protection and no coercive action. Because NBW is not there.
Yes, yes.
No coercive action shall be taken against both the petitioners. With the above observations, is that first?
Highly obliged. 7, in this case, my lord, it is a OC declared absconder, my lord. I have annexed one order passed by this honorable court, my lord. That is annexer 4, page 32. And conviction, of course, is registered case registered under section 4 of POCSO Act.
Here notice has to go.
376.
Here notice has to go.
Yeah, earlier order was also there,
Yes.
but you never appeared.
Earlier order. No order has.
No order is there.
No order is there, my lord.
No, what is the order? You have annexed or the other just
Other accused, similarly situated.
Similarly
accused, yes. Since this honorable court has already been passed, the person who is declared absconder by OC, madam. That is Supreme Court decision is there, madam.
that is there, but
That is
It's-
366 case. The
366.
order which my honored friend has enclosed.
Yes.
Pertaining
that
to-
is 366,
Six-
but
eight-
there are
two
the
nine four.
observation of the Supreme Court that the police has no power or authority to declare a person as
Yeah,
an
there's no
absconder.
power, no.
So that's why nowadays our courts are what are doing.
Yes.
They're issuing summons, not the NBW.
And-
So these are the regularizing that way only.
Yes.
Okay, issue notice, go to respond number 2.
There, madam. So I may be allowed to before the court, madam. 25.
No, that was we considered because of your child marriage was
Child.
there only. It is no issue notice. No issue notice to the respond number 2 to register judicial police station. And also call for the scan copy. Scan copy,
Yes, yes,
scan copy of the
yes,
distress. List accordingly immediately after being published.
Ultimate.
The police will also know.
Yes.
Appearance verification, my lord.
Initially, case was registered under section 87 of the BNS, that is section 366 IPC. But subsequently, section 4 is section 4 POCSO added minor. But though it is in the FIR, it is said minor, it is 12 years, but her original certificate is seized by the police, and it says 16 years, 5 months, 20 days minor. Subsequently, minor, what happened? Now, my lord, you will kindly come to page, my lord. Page 17, my lord. It is amicably settled. What happened, my lord? It is said by no. It is a girl out of love affairs. When her, my lord, my elder brother, the guardian, assisted her to meet with the petitioner, then she compelled her to take her away. It is clearly said by the information itself, page 17, my lord. And then you will also find page 19, my lord. It is the, my lord, informant who recovered the victim girl. Page 17, my lord. John Mott, declaration made by the victim, my lord, page. The last party is the, my lord, informant. Interview of the, my lord, victim. Second, matter of the penal petitioner. Here, by para 3 of the condition, the given the long-term long relationship between the Rahima Khatu and the Kabusi, both are yet to be attained age of marriage at the time the petitioner also has finally. Para 4 man. Both the parties, while found missing their children at the house, charged around neighboring areas, but they were failed to find out their whereabouts. Then after the first party lodged the written agreement with officer in charge of the police station, informing that Ramija Khatun is found missing. After that, both the parties come to know from some secret sources that the said missing children are rushing towards Borderpool from the outside. Accordingly, first party reached the Borderpool railway station and able to recover Ramija Khatun on 3/11/2022. The first party informed the Tamil police station regarding the recovery of the girl after return back to him. Then after
Your informant name is Bilal.
Bilal, the interview of the alleged.
Now, we are not in a position to say as to whether the oath was signed by Bilaluddin, because it's a very good handwritten name is there, Bilaluddin. Whereas if you go by the this FIR, it seems that it's a not written by so qualified person. But if you go by the oath, it was declaration, it's a very qualified person had put the signature. You just barely, you can see it. Now see,
Yes, yes.
that is Bilaluddin, very nicely written. Name is very nicely written. Now, if you go by the FIR, it's very not legible also, but I have seen Bilaluddin seems that it's a very not so educated person have write this one.
He puts the signature in vernacular.
In the guardian of the victim in a POCSO case cannot compromise the matter.
Cannot.
They cannot. So this affidavit is nothing, it's non-essential.
You're right,
On one hand, you are saying that your
Yes.
girl has been so and
Yes.
so, and on the other hand, you are
Because
going to
here the
compromise because
law
of
is in favor of the victim.
Ah.
And it's being a minor, she cannot compromise. The parents also or guardians also cannot compromise. There is specific order for the Supreme Court. So
yes,
this
obviously
affidavit-
there, and then question is that these are all the moneyed man side. I
yes,
think
yes.
these are all settled.
Or through pressure.
Yes, yes. Obviously, it is
So this may be
admittedly
issue
it
that
can
CD may be compromised.
issue notice corridor.
He
respondent number two.
money.
Issue notice to the respondent number 2 and also call for the case type. Notice to corridor. Yes, when it can be listed.
Why not,
Police will not going to arrest him because it is already compromised. 24 lot many matters are there. I think 24 can be or 23. 28 can be.
Yes.
Yes.
Right.
Is it right?
Yes.
Yeah.
CBN.
Yes, so without causing any preliminary inquiry, allegedly on the basis of source information. FIR starts from page 20, Lordship. Kindly come to page 22. There is the first information contents. May I please read, Lordship? A reliable source information has been received to the effect that Pinku Kumar, manager scale 3, while working as branch manager of State Bank of India, Ramakrishna Nagar branch, Karimganj, Assam, in conspiracy with middleman Shuman Pal, disbursed express credit loans to various borrowers during the period 2023 to 2024 in lieu of undue advantage bribe, which were collected by Shuman Pal and unknown others from the borrowers. Source information further alleged that undue advantage bribe of total rupees such and such, 40.995 lakhs were collected by middleman Sri Suman Pal in conspiracy with Sri Pinku Kumar and unknown others. And thereafter, Sri Suman Pal credited an amount of rupees 12.10 lakh approx in the bank account number such and such of Sri Pinku Kumar with Canara Bank, and remaining amount of rupees 28.85 lakh approx in the bank account number such and such of Priyanka Kumari from his bank account. Source information also alleged that after obtaining the undue advantage bribe from Sri Suman Pal and unknown others, Pinku Kumar tried to revert the said bribe amount in the bank accounts of his relatives and others. So case has been registered. The petitioner is the Pinku Kumar, is the branch manager. Now, Lordship, I have annexed certain documents. There was no preliminary inquiry. Our understanding is that had there been any preliminary inquiry, perhaps it could have been avoided. No, it is regarding Ramkrishna Nagar branch, Lordship. Page, Lordship, may kindly come to page 26. Is the employees by biodata. Page 26. Column, Lordship. 5-6 columns. A second one, position designation branch manager, Ramkrishna Nagar branch. From 3/7/2023 to 19/3/2024. This was the period he was there. Now, what happened, Lordship? Suman Pal is the accused number 2 here. When petitioner was in Tarapur branch of Silchar, we have made specific statement. He came to contact with him. He has this property in Patna. It's from Patna in the name of his wife. He was looking for selling out for purchasing a flat. Accordingly, this Suman Pal proposed for purchasing, and they have an agreement with his wife. Page 5 now. It was dated 23/5/2023. Between Priyanka Kumari, is my wife, and is Suman Pal. And consideration price was fixed for rupees 58 lakh, out of which on different dates, all by bank transfers, he has paid 41 lakhs. And it is true, 41 lakhs, out of this 41 lakhs, 28 lakhs something was deposited in the name of, in the account of Priyanka Kumari, and 12,10,000 in my account. That is not true. But subsequently, this,
Priyanka Kumari is your wife.
why my wife. Subsequently, Lordship, this accused number 2 rescinded from the contract, and he issued a letter on 2/6/2024, page 40, and demanded the money back because he has purchased a or he wanted to purchase a property in hometown. His hometown is Hailakandi. Thereafter, he also issued a legal notice dated 10/9/2024, demanding return of money.
Now, how these are related?
Related because these amounts which they are saying these are bribe amount deposited in my wife's account and my account. These are against this agreement.
These are your.
Oh, that is what I will cooperate with the investigation. Let me explain these things, because they have also searched my residence at Silchar while I was in Patna, because my wife was undergoing this surgery. His search was made on 27 March. And from 20 to 26, 22nd to 26, she was admitted, and I have annexed her medical record also, Lordship. There was a removal of his ovary done. I will cooperate with the investigation. I will explain. These are the documents. They have also seized those documents from my residence at Silchar.
Yes.
The FIR is of 25th March. My father case that you know, the provision of the same motion.
Yes, because it's a very, yes.
It's a case. And unofficial, whatever information I have got, he is moving around. He is not to be got pulled off.
No, he is now in Silchar itself. He is now in Silchar itself. On that point of time, when they have started, he was in Patna. treatment lordship. I have annexed these documents.
Okay, we should require call for the case study. Had Mr. S.D. Forecast and also had Mr. R.K.D. Chaudhary, the standing counsel CBI. Call for the case study. Yes, when it can be able to fix, it will be obviously after Bihu, not before Bihu.
8th,
20,
28th.
28, 28, it can be.
So I am ready to cooperate with the investigation.
Let us see, it's a very initial stage. 28, for case study.
For retaining item 10.
Then. A.H. Sarkar is not here. CD we have received. CD we received, Bolwa.
It's a CBI now.
Oh, you also, acha, oh, you are here.
In fact, Lordship, the only ground for seeking bail here is the delay in the completion of trial.
Acha.
Now, what has happened here is he was arrested in 2002. The accused person was arrested in 2002. Trial was going on, he was granted bail. In 2003, he absconded. He was not to be found, and ultimately, after getting warrants from the Honorable Court, he was again apprehended in the latter part of 2022. That means 19 years he was not there. Now the plea of delay in trial, Lordship, perhaps, because it was stuck up because he was not there.
But whatever, he is behind the bars since 2022 now. Now.
22.
But since 19 years, he was been absconding.
He got bail earlier, and then he absconded.
Now, the petitioner side is not available. Otherwise, you have the case record, I think. Is it charge sheeted one, I think?
It is charge sheeted.
So now what is the stage of the case at present?
Special judge was not available in Richmond. He used to join in a few days, and the matter is fixed on 9th.
Right. For recording of evidence or?
In fact, two witnesses have already been
Already
examined
examined.
before.
Hmm.
That is in 2003.
Now he is not available, so we'll fix the date. Petitioners is absent on call. Please the matter accordingly after due petition.
Now should be fixed date.
Pardon?
Now should be fixed date.
You want any fixed date or otherwise after Bihu? Because he is present, but he's not absent. Mr. R.K.D. Chaudhary, naam to likhiye.
11.
What the mic is
Hello.
not here today.
This section, this is section 64 BNS, reduced section 6 of POCSO. You know, if I was arrested on 20/10/24 year,
Arrested on
28/10/24.
8/10/24.
I am behind by more than 160 days. Well, Your Lordship, during the pending.
No, you are 28/10/24.
24.
More than
160 days. This charge sheeted already. During the pendency of this case, charge sheet was submitted, Your Lordship.
no. Again, you say you got arrested in connection with this case 28/10/24. Then how 1 year?
So not 1 year, 160 days.
160 days.
Yes. Then during the pendency of this case, okay, charge sheet was submitted, Your Lordship.
While he was in custody,
Yes,
CS was submitted.
yes. Still he is in custody, Your Lordship. Your Lordship, the week FIR page number 22.
Right, okay. So it's either, it's a second.
Birth certificate shows that the victim date of birth is 14/7/2007.
He fixed it at 22.
20, page number 22, the seizure list.
Seizure list.
I've got a birth certificate. There is the birth certificate was seized by the investigation officer, where her date of the victim date of birth was shown as 14/7/2007. There's 17 years at this time, at that point of time. And another there is the page number 30. Page number 30. A letter was given by Gao Pradhan saying that the victim girl, who alleged to be 17 years as per her birth certificate, she was married to another boy prior to 2 years, 7 months before the incident. Your Lordship. Page number 30. Though this is her age was calculated as 17, but the Blaze Pardon, who is the head of the family, he has given a letter saying that victim girl, who at least 17 years, she was married to another boy before 2 years, 7 months. This is the factual, Your Lordship. At this point of time, Your Lordship. So the charge sheet was submitted, Your Lordship. Charge sheet was submitted on 22/12/24. LCA was called for on the last, the LCA was received, the Lordship. The Lordship may produce the charge sheet, Your Lordship. This charge sheet which they submitted, Your Lordship. Though there was a dispute of marriage, Your Lordship, that the victim girl was pregnant for 2 months, as the FIR says. So there was a marriage dispute between the determination of the husband, Your Lordship, at this point in time. The charge sheet was submitted, this charge sheet was incomplete, charge sheet was submitted, Your Lordship. Though within the time, and this charge sheet was submitted on 22/12/24, and this charge was incomplete charge sheet. Kindly that may tell us what they have written in the charge sheet.
You have annexed this one or here?
No, in LCR. Page number 6 of the charge sheet. The last part.
Is it a case of this related to this one? Mhm. Yeah, proceedings presentation of what happens. Such as not required. Charge sheet in which para you are relying?
Page number 6, last part. Last 4-5 lines. May I read it? Huh? Sir, I am submitting the charge sheet against the arrested accused persons, namely Prasanta Saika, so and so, with a request to the Honorable Court to accept the same. Moreover, I will submit the additional charge sheet. They will submit additional charge sheet as per the statement. This charge sheet is incomplete charge sheet, Your Lordship. Just to keep me behind the bar, Your Lordship. Just to file within the stipulated time, Your Lordship. This they had hurriedly filed without receiving the FSL report, which is very important in this case, Your Lordship. Your Lordship, in this regard, Your Lordship, I place a judgment also on the last occasion. Lordship may find in the record. Lordship, this is Ritu Chavadia, Your Lordship, Union of India and others, Your Lordship. Your Lordship, in this case, Your Lordship, Your Lordship, 3 issues were framed, Your Lordship, in this case, Your Lordship. So page number, paragraph 9, Your Lordship. Can a charge sheet or a prosecution complaint be filed in a piecemeal without first completing the investigation case? Second issue was whether the filing of such a charge sheet without completing the investigation
will extinguish the right of an accused for grant of default bail, whether the remand of the accused can be continued by the trial court during the pendency of investigation beyond the stipulated time as prescribed by the CRPC, Your Lordship. And this has been determined, Your Lordship. Page number paragraph 33, Your Lordship. This issue has been discussed, Your Lordship. Paragraph 33. Point 1, Your Lordship. Without completing the investigation case, a charge sheet prosecution complaint cannot be filed by an investigating agency only to deprive an arrested accused of his right to default bail under section 162 of the CRPC. The charge sheet was incomplete. Just to deprive me from default bail, this charge sheet was submitted. Secondly, such a charge sheet, if filed by an investigating authority without first completing the investigation, would not extinguish the right to default bail under section 167(2) of CRPC. The trial court in such case cannot continue to remand an arrested person beyond the maximum scheduled time without offering the arrested person default bail. As per Your Lordship, I've allowed default bail, Your Lordship, though the charge sheet was submitted within the time that charge sheet, as per the statement, Your Lordship, that is, the charge sheet was incomplete charge sheet, Your Lordship. Hence, I may be allowed, Your Lordship.
But now at this stage, you are going on default bail. At this stage of that, when the incomplete charge sheet was filed. That is your right accrued at that time only. Why don't you appear and file for the default bail?
This bail was pending before filing the charge sheet. Since
this one?
Yes.
This bail?
This bail was pending since before filing the charge sheet, Your Lordship.
Is it?
On the judgment, I have a commission to make. Subsequently, we have the Honorable Supreme Court. Like you.
Whichever person.
Chabaria, which is the writ petition 60 of 2023. I thought this case, the Director of Enforcement versus Manpreet Singh Talwar. Here, my lord, the next page, my lord, it says, my lord, in continuation of the interim order of the court dated 1 May 2023, we clarify that the order shall not preclude any trial court or, as the case may be, the High Court from considering an application for the grant of default bail under section 167 of the Code of Criminal Procedure Code, independent and without relying on the judgment dated 26 April 2023 in writ petition criminal 60 of 2023. It's talking about this Ritu Chabaria, my lord. Subsequently, my lord, this case has been referred to three-judge bench. This is another order that I have sent to your lordship, one pager. It says leave the proceeding on these days before the bench of 3 judges. And my lord, there is another judgment which the live law copy I have shared with the lordship. Here, my lord, specifically, this is my lord Central Bureau of Investigation versus Kapil Wadhwa. My lord may come to paragraph number 23, my lord. Para 23.
Para 23, which one? This
live law judgment, my lord.
Yes.
Yes. Para 23, my lord. May I read? My lord. It says the benefit of the provision appended to subsection 2 of section 167 of the code would be available to the offender only when the charge sheet is not filed and the investigation is kept pending against him. Once, however, the charge sheet is filed, the said right ceases. It may be noted that the right of the investigating officer to pray for further investigation in terms of subsection 8 of section 173 is not taken away only because a charge sheet is filed under subsection 2 thereof against the accused. Though ordinarily all documents relied upon by the prosecution should not accompany the charge sheet, nonetheless, for some reasons, if all the documents are not filed along with the charge sheet, the reason by itself would not invalidate or vitiate the charge sheet. It is also well settled that the court takes cognizance of the offense and not the offender. Once the material produced along with the charge sheet, the court is satisfied that the commission of an offense takes cognizance of the offense allegedly committed by the accused. It is immaterial whether further investigation in terms of section 173 is pending or not. The pendency of further investigation qua
the other accused or for production of some documents not available at the time of filing charge sheet would neither vitiate the charge sheet nor would it entitle the accused to claim right to get default bill on the ground that charge sheet was incomplete charge sheet or that the charge sheet was not filed in terms of section 173(2) of CRP. So now it's very clear that it's not getting the benefit of part charge sheet. One, my lord, this should not be relied on, and then subsequent judgment of the Honorable Supreme Court, the 24th January. So the petitioner will not get benefit from the Ritu Sabaria case. And in the meantime, my lord, the cognizance has been taken of the offense. 164 has been recorded. So let the victim be examined, my lord. In the 164, the victim has implicated the petitioner, my lord, the accused petition. In terms with the Wadhwa case.
In this present situation, Your Lordship, the FSL, how far the FSL is important in determining the case, Your Lordship. Whether the FSL is important to determine the case or not, that is to be considered. Because whether there is a dispute of marriage, this to determine that the proper pregnancy, that FSL.
The girl was pregnant at the time of filing the lodge, FIR.
Admittedly, she was a minor. The crime has been committed.
Whether she is married to someone or doesn't matter.
She may get married to someone at the age of 14 or 15 also. That is not the question. Marriage is not because but the admitted position that she was a minor at the relevant time of it.
She was minor. The pregnancy was to be determined by the husband has to be determined. That she was.
So that's why most probably the notice and sent, I mean, the DNA or what is the application?
FSL also, and that is yet to receive.
It's a matter of trial. If it doesn't receive, then obviously, anyway. Yes, brother. Yes.
No, Doshi may kindly pay the search sheet, my lord. Search sheet last paragraph, my lord.
Yes, charge sheet last one. Yes.
So my lord, last few lines, my lord. First and foremost, my lord, it has not been mentioned that this is a part search sheet, my lord. This is my humble submission, this is a complete search sheet, my lord. Why I am saying, my lord?
But the prayer was there, I think.
No, my lord, that is my lord. That has to be interpreted, my lord. So as per the suggestion of the superior authority, I am submitting this search sheet, my lord. It is not such a part search sheet or half search sheet. Part search sheet against the arrested accused person, namely Chief Prasanto Soikia, agent of so-and-so, son of so-and-so, resident of so-and-so. These lines and lines are very important, my lord. With a request to the Honorable Court to accept the same. Moreover, I will submit the additional search sheet after receiving FSL report of DNA analysis from the concerned authority if found positive. So, the statute has given the right to the investigative officer to do further investigation. Where is the bar? He said, my lord, if the FSL report come positive, my lord, then he'll file an additional search sheet. Now, can this search sheet can be termed as a part search sheet? This is the final search sheet. If it is nowhere stated that my lord, investigation is not completed, but my lord, as per the request of the my lord senior authority, I am submitting the certificate. This is not that, my lord. This is the final search sheet, my lord, and there is a provision, my lord, to do further investigation. So, as per the my lord report of the IO, my lord, he said if the FSL report comes positive, then he will file an additional permit. Then how can my lord this search sheet can be my lord termed as a my lord part search sheet? My humble submission, my lord, this is not a part search sheet, my lord, this is the final search sheet, my lord. And there is a power, my lord, to the investigating authority, my lord, given by the statute, my lord, to do further investigation.
This is not denial of the charge sheet. Charge sheet is submitted to us. there is specific prayer of there, they will file additional charge sheet. What it means? It means it's incomplete charge sheet they had submitted. They wanted,
if report comes positive, then only.
even though they have to submit the report, whether this is positive or negative has been obtained, yet to be submitted. I am behind about more than 160 days. At any condition.
Okay. I'll pass the order. I'll put some of the citation also. It may be in the order. I'll pass in the chamber.
Obliged.
It will be like this.
Item 12.
May I please honest? My lord, petitioner is behind me by last 130 days, 4 months, 10 days, my lord. He has got the lesson, my lord. He has this. 47, my lord, in this case. I was shown as exponent, my lord, by the police, my lord. Thereafter, my lord, immediately, my lord, after receiving of the charge, my lord, learned court below lordship, he passed the issue NBW. On the state of the NBW, my lord, I was arrested, my lord. I was arrested on 27/11/2024. Now today 130 days. Which was issued by the opposite party has appeared. That's it. Finally, NBW order, lordship, we filed case number 13. On 16/5/2022, case report we received on being transferred from Learned Special Guard Dorong Mongoldo for disposal. Perusal of case record reveals IO has filed CS against accused person, namely Sankodas, present petitioner, S. F. Sonda, issue NBW. Against that. The FIRs lost by the father of the victim, who is a LSTV 17 years old. There is no disputed lordship. There is a law of affair, therefore CL of the petition. Sasi that as a responder, Sasi to filing the case record also. I have also filed an additional affidavit lordship. Additional affidavit page number 31. Yes. Page number 31, my lord. CL number 2, absconder, my lord. Absconder. The paragraph is said also there is medical record, my lord, which is in my favor. There is no, my lord, my lord, activities in others, my lord, there is no assault in the medical report also. I'm not going on to the merit also, lordship. Only the 130 days, my lord, for the purpose of trial, my lord, further custodial intervention against my lord may not be necessary. Because my lord, I require to defend myself also. In fact, my lord, there is also of going on for marriage lodging. Now, at present, she is now 22 years. Yeah, FIR was in the year 2020, my lord. At that time, my lord, she was 17 years, my lord, which is not disputed age. Now 22 years, my lord, there is a law of FIR, that's it. Now she is 22 years. Marriage is also going on also. So, my lord, other custodial interrogation, my lord, detention is not, my lord, for the purpose of trial, that's it. May not be necessary, only to 130 days. Moreover, my lord, I arrested on the scheme of an MBW, my lord. Lordship is aware, lordship, police cannot submit such my lord as absconders. Police has no power. It is held by this honorable court also, my lord, honorable test court also. I have also cited one judgment, my lord, in my additional affidavit in our High Court, my lord, Kabir Ahmed versus State of Assam, 2011, 1 GLT 561. In that affidavit. Anyway, even after filing of the absconders, court cannot directly issue the MBW. At least give me a chance. Oh, it's not going to download. Therefore, I'm not going into the too much merit lordship. In the technical ground also, already I have learned sufficient lesson learned the last 130 days. Considering the age of the victim also, it's not 12 years or 11 years. So as per medical report, I have seen lordship. There is no recent sexual activity and there is no assault in the medical report also. That is my humble submission, lordship. At least I may be allowed to defend myself, safety, my lord. In that case, lordship. That is my humble prayer.
Which I investigated. That is why, my lord, while filing charges, my lord, he was shown as an absconder, not declared, my lord, shown as an absconder, my lord. Now, my lord, yes, my lord, that order, my lord, issuing non-bailable warrant of arrest in the first stage, my lord, that he has not challenged, my lord. Otherwise, my lord, pursuant to the Indromon Musabi case, my lord, that cannot be, my lord. The first stage, my lord, MBW cannot be issued, my lord. But he has not challenged this order, my lord. Now he has filed his bail application, my lord. Now I have seen the scanned copy of the record, my lord, on 4 to 2025 service letter. That, my lord, I was in a relationship with Shankorda since last two years, but the physical relationship that was, my lord, it forced, my lord. It was in force, my lord. He committed in by force, using force, my lord. And my lord, since I refused, but he did not listen to me. That is the line, my lord. That was not consented, my lord. And even, my lord, she given consent also, my lord, since he was minor, my lord, that day I was committing the offense. So her consent have been not valid. My humble concern, there is a victim examination. So this is a bail application. He has no penalty, but he has no practice application for the penalty that order.
I got, I'm not getting any sound, my lord. In the medical report, my lord, kindly see my medical report. There is no, my lord. In her statement, it is said, my lord. Medical report support. In the medical report, my medical report is taken to it's necessary. In the blood. Yes.
The opinion decision.
Proceed even, my lord, there is talk is going on for marriage watching. Now she is 22 years old. What purpose will my lord serve, my lord, behind?
With this petitioner,
No, my lord,
with whom she got married?
victim, my lord, no, talks is going on, lordship.
Not with whom?
With the my lord, victim, lordship.
The
Yes, yes.
petitioner.
Yes, lordship. Now she is 22. The incident time, my lord, she was
17
20
years.
years. Lordship.
Yes.
Kindly consider me.
Yes.
As per instruction, lordship, if lordship allows the bail, lordship, but lordship with some certain observations that the trial should not be hampered because some marriage talks are also going on, that is admitted, Lordship. But trial status is important, Lordship. It is not only compulsory.
No, trial will look after, but you say that, what is the position? Is there any talk on marriage is going on?
Lordship,
Have you done instruction? Because he is saying that there is a talk of marriage, compromise or marriage possibility is there between them. Is there any, do you have any instruction?
let me go through it. Lordship, in that case, Lordship, because the counsel for the informant is Mr. US Vora, Lordship, but he has instructed me over phone that he is not available to put the outside.
No, it's okay. And from your instruction, what is your instruction? Is there any talk of marriage?
Yes, Lordship. I have obtained instruction from the learned counsel, but not from directly from the client or person.
No,
because I have
learned
not- I
counsel,
have not
from the
signed the
learned
contract.
counsel, you got the information that
Yes,
talk
yes,
of
yes,
marriage
yes,
is going
it's
on.
going on.
That's what I'm asking.
Yes.
130 days, my lord, kindly consider. 130 days behind the bar.
He was not
Directly-
cooperating, just Borba has said that he is not
That is the
cooperating at
application
that
also.
time.
Anyway, my lord, if I.
Otherwise, Mr. Borba, from her statement, she may not be a consenting party, but most probably the relation was consensual. It seems.
Last 2 years. This is-
Love affairs.
There is no dispute, my lord. Age is not also disputed.
Yeah, obviously.
Nowadays, my lord.
Nowadays, everything is possible.
In nowadays, my lord, only for high secondary, my lord, we are. So now you have, from high school, they are low. Anyway. There is a.
They are so smart from high school.
From high school, my lord. Smartphone is their lordship. They are too
A
much.
smartphone makes them smart, in fact.
Yes. That is the thing, my lord. It's not a 11 or 12 years, it's 20 years. And also, my lord, considering BW.
Heard Mr. has brought a good learned counsel for the petition. And also heard Mr. R.J. Borba, the learned additional PP, appearing on behalf of state respondent. And also heard you are Mr.
H. Mojumdar, representing US Vora.
H. Mozumdar, appearing on behalf of Mr. U.S. Borda for the respondent number 2. As the scan copy of the case record has also been received. Where is this? But I got this an application already. It is submitted by Mr. Botapul that both the accused petitioner and the victim had love affairs. And out of the love affairs only, they eloped. And thereafter, the FIR was lost by the father of the victim. But he was not aware about the lodging of the FIR, and police never searched for him during the investigation. But subsequently, came to know that he was shown as an absconder in the charge sheet. But the learned trial court below had issued NBWA on the very first day of receipt of the charge sheet, or on the very first day after the case being transferred. That is on 16/3/2022, the NBW was issued against the present petitioner without giving him any chance to appear. No, NBW and without giving allegations, NBWA, and no summons were issued to the present petitioner. He further submitted that the police has no authority to declare any person as an absconder, but the learned session judge, without considering the said fact, had issued the NBWA on the very first day. On the strength of NBWA, the petitioner got arrested in connection with this case, and he is in custody last 130 days, 30 days first. So considering his period of detention, he may be enlarged on bail. Further, Mr. Botapur submitted that the girl was admittedly more than 17 years at the relevant time of incident. And then there is no medical evidence against the present accused petitioner, as no injury or was found at on the private parts of the victim at the time of one examination. Further, Mr. Botaku submitted that the girl is presently is 22 years of age, and the talk of marriage is also going in between the petitioner and the victim. Accordingly, he submitted that further custodial detention may not be required at this stage. He will regularly appear before the learned trial court below, as and when the date is fixed, if his bail prayer is considered. Next one, Mr. Botaku, the learned additional PP submitted in this regard that that CS has already, the charge has already been framed on 4/2/2025, and the witnesses, including the victim, is yet to be examined in connection with this case. However, further he submitted that as per the statement of the victim recorded under section 183 CRPC, the physical relationship was forceful, though she admitted that they had the love relationship with each other. Accordingly, Mr. Borwa raised objection and submitted that till the recording of the evidence of the victim, his bail prayer may not be considered. Next para. Mr. Mr. Bora.
Ace Mojumdar, Your Lordship.
Mojumdar.
Ace Mojumdar.
Mr. Mojumdar, the learned counsel appearing on behalf of the respondent number 2 submitted in this regard that the trial is yet to be commenced, and there should not be any hampering or tampering with the evidences if the bail prayer of the present petitioner is considered. However, he submitted that as per the instructions, there was talk of marriage between the petitioner, marriage between petitioner and the victim is going on, and admitted at present the victim is a major girl. Considering the entire facts and circumstances of this case, submission made by learned counsel for both sides, and other aspects of the case, I find that further custodial detention may not be required in this case, and accordingly, I find it a fit case to allow the accused petitioner to go on bail. So and so. To whose satisfaction?
Special was for Dorong.
Special just or okay, you're granted.
High level. My name is D Google.
Oh, you are appearing for?
Mr. S. Bothakur. My name is D Google.
D Gogoi Koido. So what? Appearing on behalf of Mr. S. Bothakur, Baki Black of D Gogoi. Mane Gogoi Koido. Okay.
My love. I'm obliged. High level.
30.
May it please your lordship.
Yes.
In the NTPS matter, my lord, where the petitioner was arrested, my lord, he is in custody from 1 year, 3 months and 23 days, my lord. So it is almost, my lord, 1 year, 4 months, my lord. I will take your lordship to the FIR, my lord. The FIR lordship will find at page 18, my lord. The page 18, my lord. The first paragraph I will skip, my lord, is only regarding the reliable information, my lord. The second paragraph I will read, my lord. At about 8:55 p.m., I along with accompanied staff arrived at Bhadarpur, Borbari, and a Naka was placed near Durga Mandir distributor Nilam Bazar, NH8, and at around 9 p.m., a white color alto car bearing number so and so from Karimganj side to Nilam Bazar via NH08. On seeing the police personnel, one number of occupant, that is driver of the said vehicle, namely Mitiul Ahmed, able to fled away from the vehicle, but Siabuddin and Abdul Mannan was apprehended. On questioning, Siab and Abdul Mannan admitted that there were drugs inside the vehicle, and they came to deliver the drugs, one namely Jahidul Islam. Thereafter, Jahidul Islam, son of so and so, so and so, so and so. Thereafter, I came, I called some independent witnesses to the spot. So, my lord, thereafter, my lord. So, my lord, here, my lord, the driver of the vehicle was Midul Ahmed, my lord. The persons, my lord, Shiabuddin and Abdul Manan was there in the vehicle, my lord, from whom the contraband has been seized, my lord. And they have came to deliver it to one Jahidul Islam, my lord. The petitioner before your lordship is Wahid Hussain, my lord. He is nowhere connected to this incident, my lord. Lordship may kindly come to the next page, my lord, at page 19, my lord. The accused person, my lord. The name of the address of the persons are Siab, Abdul Mannan, Mitiul Ahmed, and Jahidul Islam, my lord. So these are the 4 name accused persons, my lord. Thereafter, my lord, the Caesar, my lord, I am skipping Caesar, my lord, and forwarding report at page 26, my lord. In the forwarding report, my lord, forwarded this Siabuddin and my lord and Abdul Mannan, my lord. There was at page 27, it was mentioned, my lord, at line number 6, my lord. Lordship may kindly see page 27 on questioning, my lord. Line number 6, my lord. On questioning Siabuddin and Abdul Mannan, they are the persons who are apprehended, my lord. Admitted that there were drug inside the vehicle and they came to deliver the drug, one namely Jahidul Islam, my lord. So ultimately, my lord, the persons who are involved in the entire incident is, my lord, the Abdul Mannan, Siabuddin, my lord, and Jahidul, my lord, and the Mitul, the driver, my lord. Now, my lord, what has happened? The petitioner was arrested, my lord. The petitioner, my lord, while Jahidul was arrested from the vehicle, my lord, this, my lord, the instant petitioner, he was there in that vehicle, my lord, accompanying him, my lord. So he was arrested, my lord. So if we, I will take your lordship to the forwarding at page 29, my lord. Page 21 is their forwarding, my lord. And lordship, my lord, at page 30, the same thing has been mentioned, my lord, at line number 3. They came to deliver to Jahidul, my lord. And the ground of arrest, my lord, lordship may kindly see at page 31, my lord. It was specifically mentioned, my lord, during the time of inquiry, while the FIR named accused person, Jahidul, apprehended. At that time, accused Wahid Hussain was accompanied with him, my lord. So he was there accompanied, my lord. No, from his possession, nothing has been recovered, my lord. Now, my lord, when he was arrested, my lord, I have filed an additional affidavit, my lord. Lordship may kindly see, my lord, the page 64, my lord. Page 63, my lord. The additional affidavit, my lord. There, the notice under section 50 CRPC, my lord. That is now, my lord, is 47, my lord, BNS. Lordship may kindly see, my lord. That is the info. They have only mentioned about the PS case, my lord, and it is mentioned, my lord, you are hereby informed. Lordship finds, my lord. You are hereby informed that you have been arrested in connection with the above noted case and will be produced before the honorable court today on so and so in connection with the case. As the case is non-malleable one, you may apply before the honorable competent court for your private counsel, government pleader provided government provided counsel for your bail, etc. The name of the accused, my lord. No ground of arrest has been mentioned, my lord. Thereafter, my lord, I have also annexed the arrest memo, my lord, at next page, at page 64, my lord. Is a type copy 65 is the original one, my lord. My lord, nowhere, my lord, the ground of arrest has been mentioned, my lord. Lordship, my lord, has already decided, my lord, in several cases, my lord. I'm just placing some of the judgment, my lord, right from, my lord, the judgment of, my lord, Bihan Kumar to, my lord, POCSO, my lord, and some judgment of your lordship, my lord. I'm just giving it to your lordship. I've also mentioned, my lord, the relevant paragraph, my lord. So Bihan Kumar, I will not trouble your lordship with all these contents. Lordship is already aware, my lord. So in Bihan Kumar, paragraph 14 and 16, my lord. 14 and 16, my lord, that speaks about, my lord, that article 21 and 22, my lord. That is, my lord, the ground of arrest has to be explained, my lord. It is a violation of constitutional rights, my lord. And thereafter, 16 is there, my lord. It has been, and I will just read 16 once, my lord. In Bihan Kumar, my lord. 16 says, when an attempt was made by learned senior counsel appearing for the first respondent to argue that after his arrest, the appellant was repeatedly remanded to custody, and now a charge sheet has been filed. In our case, also charge sheet has been filed, my lord. His submission is that now the custody of the appellant is pursuant to the order taking cognizance passed on the charge sheet. Accepting the such argument with great respect of the learned senior counsel will amount to completely nullifying the Article 21 and 22(1) of the Constitution. Once it has been held that the arrest is unconstitutional due to the violation of 22(1), the arrest itself is vitiated. Therefore, continuing custody of such a person based on the order of remand is also vitiated. Filing of charge sheet or other order of cognizance will not validate any arrest which is per se unconstitutional, being violative of Article 21 and 22(1) of the Constitution of India. We cannot tinker with most of the important safeguards provided under Article 22. So thereafter, my lord, I'm just relying some paragraph from POCSO, my lord, that's flag number 2, my lord. Yeah, that is there, my lord. And lordship judgment that I want to rely, my lord. Lordship judgment, my lord, at serial number 3, my lord. That's flag marking number 3, my lord. That is bail applications 447, my lord. In case of Zakir Hussain, yes, Zakir, my lord. In that case, lordship, my lord, I'm relying from right from para 10, my lord. Lordship has explained, my lord, the ground of arrest is mandatory, my lord. In violations, my lord, not shown is violations of Article 21 and 22(1), my lord. So in that count itself, my lord, the petitioner is entitled to enlarge on bail, my lord. So this judgment I am relying, my lord. And my lord, if you go by the charge sheet, my lord, I will just show your lordship the charge sheet, my lord, because no contraband has been seized from my possession. Secondly, my lord, the only allegations against me in the charge sheet, my lord, at page, my lord, lordship may kindly see at page 51, my lord. The CDR, my lord. Page 51. Wahid Hussain alias Mahmoud is a petitioner before lordship, my lord. So he is the receiver of the drugs which was seized from the possession of the accused Shihabuddin Abdul Manan. During his CDR analysis, it is found that they are in continuous touch with each other and they were doing the same business for many days. This is the only allegations. And now, my lord, at page 47, my lord, what is the documents that have been annexed and that has been, my lord, relied on by the prosecution, my lord? That is shown, my lord, at page, my lord, page 47, my lord. Page 47, my lord. D31 is a document, my lord. It's CDR analysis. If lordship peruse, my lord, the documents, my lord, that is the statement, my lord. And the honorable, I've annexed, my lord, one judgment of the Jammu and Kashmir, my lord. It has been held, my lord, that CDR statement is not enough, my lord. Voice recording is mandatory, my lord. If lordship may kindly see that serial number 6, flag mark serial number 6, my lord. Or serial number 5, my lord. The paragraph, my lord, 16, my lord.
Which one? 5.
5, my lord. Paragraph number 15 and 16, I will read, my lord. So far as the details narrated by the co-accused to the police officer about involvement of the petitioner are concerned, the same are also hid by provision of section 26 of the Evidence Act and are inadmissible in evidence. The Supreme Court, in case titled as Tufan Singh versus State of Tamil Nadu, has held that the confessional statement made by an accused against the accused before the police officer is inadmissible in evidence. Again, this court, in the case of so and so, has held that the statement of the co-accused while he was in police custody in the presence of police officer is inadmissible in evidence. Thus, even the details about the involvement of the petitioner as alleged in the crime deposed to by the co-accused to the police officer are not enough to implicate the petitioner. The next para 16, my lord. The only material that connects the petitioner to the alleged crime is the CDR, which has been collected by the investigation agency during the investigation of the case. As for the analysis of the CDR, it appears that the petitioner was in touch with the co-accused during the relevant period. The question arises as to whether the same would be sufficient to prima facie hold the petitioner guilty of having committed offense under 27A of the NDPS. In the opinion of this court, CDR details showing contact between the petitioners and co-accused without there being any voice recording relating to the conversions between them, they may not be sufficient to convict the petitioner for an offense under section 27A, though it raises the suspicions about his involvement in alleged crime. So in the instant case also, my lord, the voice recording was not there, my lord. The only allegation is the CDR against me, my lord. So taking into consideration all aspects, and my lord, the judgment that I have relied on, my lord, and lordship judgment is already there, my lord. On the same facts, my lord, I'm praying for the enlargement of the bail because already is in custody for 1 year and about 4 months, my lord.
Yes.
my lord, in this case, my lord, searches submitted, my lord, under section 22C, 25 and 29, my lord. That has to be taken to note, my lord. Apart from, my lord, commercial quantity, my lord, 29 was also added, my lord. Now, my lord, on 39/2024, charges framed, my lord, against the 5 accused person. Because three accused person, my lord, they were together, traveling in a vehicle from where my lord, contraband was recovered. One person fled away, my lord. Now, my lord, two person, my lord, that is Zahirul Islam and Wahid Hussain, that is the my lord, instant petitioner, my lord. They are the receiver, my lord. Now, Lordship, my understanding is already read the, my lord, page number 51, my lord, 51, paragraph 4 of the search sheet. My lord, may I just read again, my lord? My lord, regarding Wahid Hussain, my lord, he is the receiver of the drugs, which was seized from the possession of accused Siabuddin and Abdul Mannan. My lord, these are the two persons who were arrested from the car, my lord, along with the my lord, contraband, my lord. During CTR analysis, it is found that they were in continuous touch with each other and they were doing the same since many days, which is corroborated at the statement of the above accused person. On the date of occurrence, the drugs were he supposed to receive, and while he heard that the police apprehend the accused person, he tried to escape from the state. And after taking PTL, he along with Zahidul Islam, who is the helper of him, arrested from Meghalaya. The accused Wahid Hussain works with Zahidul and he delivers in local area. Because, my lord, conspiracy, my lord, it is very much, my lord, difficult to prove conspiracy with direct evidence, my lord. In Supreme Court, my lord, number of decisions it was held, my lord. Conspiracy cannot be proved, my lord, with direct evidence, my lord. There has to be some circumstantial evidence, my lord, or my lord, other evidence, my lord, which are corroborative in nature, my lord. So in this, my lord, in my humble submission, my lord, the accused person is the receiver, and my lord, it is already mentioned, my lord, because there were frequent call, my lord. There may be frequent call with other person also, my lord. But police has not arrested, my lord. My humble submission, my lord, why police has arrested only these two persons, my lord? There may be other person also with whom, my lord, they were frequent call with the accused person from whose position, my lord, contraband was recovered, who were arrested. But those persons were not arrested, my lord. Only these two persons were arrested, my lord. Because, my lord, they were in several leagues, my lord. And regarding my lord, 47 notice, my lord, now search sheet submitted, my lord. So he is well aware about the, my lord, ground of arrest. Now charges frame, my lord. During at the time of framing charge also, my lord, it was informed to him, my lord, that the contraband was recovered and you were supposed to, my lord, receive the contraband, my lord, because section 29 is there. So, my lord, he is well aware about his ground of arrest.
As regard his submission, my lord, the para 11 of the lordship judgment is clear, my lord. Para 11 lordship, CL number 11, my lord, CL number 3, my lord, the flag mark, my lord, the lordship judgment. Lordship says, my lord, it is a contention of the petitioner that non-communication of the ground of arrest is in violation of section 47 BNS, rendering the arrest and subsequent remand of the accused petitioner is invalid. The accused petitioner shall has the fundamental and statutory right to be informed about the ground of arrest in writing, and the copy of such written ground of arrest have to be furnished to the arrested person as a matter of course and without any explanation. Non-supply of the written grounds of the arrest to the arrested would vitiate the arrest, even if the case has been charged. So, lordship, my lord, I am just relying on lordship judgment, para 11 that I have already mentioned in my judgment, my lord. So, it will there, my lord. I think, my lord, he's not been communicated with the grounds, and already, my lord, lots of judgments are there, my lord, on this count, my lord. But because of non-payment. Yes.
Two witnesses.
Two witnesses out of 11, my lord.
And other one, my lord, PW2, my lord, on the same day, my lord.
In my additional affidavit, I have just annexed a copy of the statements, depositions, my lord.
10/3/2025.
25. Yes,
Recently, my lord, there are two witnesses has been examined, my lord, out of, my lord, 11, my lord. And, my lord, in their depositions, my lord, they have not explained and have not deposed anything against the petitioner, my lord.
That is, my lord, only two seizure of nothing, my lord.
Yes.
Because admittedly, my lord, seizure has not been made from the accused person, my lord. But,
Yes.
my lord, they have implicated the person, my lord, from whose possession the, my lord, seizure was made, but they have identified, my lord. And with this person, my lord, they have, this petitioner have done, my lord, direct connection with the, my lord, petitioner, my lord. And still there are other witnesses they have to be examined, other material witnesses are yet to be examined.
Yes, sir. Pass your order.
Obligation.
Custom tables separate. I don't know. I don't want to. But it is, I don't know, maybe, I mean, give this one, from the motion. This one, it is similar, I said, all of them local. This one going to be. Quoting of which also, I'll put this. Yes, I'll pass you on.
14 and 15.
Nineteen.
90 days, 90 days. This is Milord, section 61(2)80 BNS, point 4 of Dowry Prohibition Act.
The case of suicide, my lord.
So today is 90 or 19? 90. Yes,
It is here.
CD is here. So CS is not yet submitted.
Then final.
Final postmortem report is yet to receive. So otherwise also it is a 90-day offense. I think.
My lord. So, Lord, in 15 KV, my lord, the parents of the accused petitioner in 14 and the brother.
Okay, that too we have to go through, but I'll give this one 14. 14 to Robertson. Item number 14. Heard Mr. A.W. Aman, Learned Counsel for the petitioner. And also heard Mr. R.R. Kaushik, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Aman that without going detail into the matter of no. Submitted that today is the 90 days of his custody. And accordingly considering, but till date, I could not furnish the charge it, and accordingly he entered his 44 pay. Next one, Mr. Kaushik, the learned additional PP submitted in this regard, that there are sufficient committee matters against the present accused petitioner. However, the case is still under investigation and final PM report is yet to be collected by the IO. Next, in view of this, without going into the merit of the case, considering the length of detention of 90 days, it is seen that the accused petitioner is entitled for bail, accordingly bail be given. To whose satisfaction, this one? To whose satisfaction?
This is Milord, Noga, Huzai.
Session judge or additional?
This is Lockup, yes.
Oh, actually, it is not yet charge sheeted.
Not yet.
So before CGM court.
CGM.
To the satisfaction of CGM Nagaon. CGM हो जाए or CGM Nagaon, I think, na? CGM हो जाए. Okay, sorry, CGM हो जाए. Yes, now come to 15. So these are this one, that one for the husband, and these are the parents and brother-in-law.
I would like to take your lordship for the FIR, my lord. FIR, page number 12, my lord.
Yes.
My lord, from the last para, today on 4/1/2025, my family and I became aware of that Ankita Sarkar is dead and her body is in the house of the accused person. Upon learning of the incident, I informed the police personnel at Lanka police station. The police personnel went to the house of the accused person, and we and our family members also went to there, and we saw the dead body of Ankita lying in the courtyard of the house. Subsequently, the Lanka police station took the body to the station. The accused person had kept the body of Ankita Sarkar a secret. Now, my lord, she died on the same day. The body was recovered on the same day, and it was lying on the courtyard. There is no reason to keep it a secret, my lord. And my lord may go through the case diary. This is the case of suicide, my lord. The unfortunate victim, who is the daughter-in-law, so they are also aggrieved party. And she was also pregnant, my lord. So everyone is aggrieved party here.
And unfortunately, in item 14, your lordship has seen that she has done, this husband has undergone 90 days of imprisonment. My lord, I may be, all these petitioners may be my lord, granted bail.
Operate. It was suicide. Unfortunately, she was going through depression. She's tragic state. The reason why the parents of the victim filed is because they were not happy with the man. They allowed, and it's always the couple will be contact. That also become one reason why she was undergoing depression.
It's a case of suicide.
Without never.
Yes, what are these?
Companies, he was tortured and he also paid some money for dowry, my lord, as per the company's person, my lord. Otherwise, my lord, whether it is suicide or not, I
No, no, that part is okay, suicide, but the, against these three petitioners, what are the allegations?
Going by the complaints, they demanded dowry and he has paid. My lord.
These persons also implicated.
Implicated as per the complainant's person.
According to FIR, right?
Arrest any.
FIR and his statement, my lord. And one thing is there, my lord, these petitioners, my lord, item number 15, I have found their statement in the city, my lord. They appeared before the police and recorded their statement.
Do you have any instructions in that regard? Because their petitioners' statements are available.
They are not in interim.
No, they will not in interim. You are saying that petitioners' statements are available.
Yes.
So whether they appear before I or otherwise, in earlier
They were-
occasion.
According to my information, they were not.
In that case, my interview is not required, Mila. Anyway, it's going in our favor only, Mila.
There is a statement.
Radha Raman Kundu.
Yes, three petitioners are here.
Yes.
Even my custody
Nepal
is
Kundu.
not required, my lord. I may be enlarged on this. If required, I will appear again, my lord.
Statements are there.
I will appear again if required, I will appear. Only show that I am cooperating with the investigation.
During investigation, they were maybe called
Yes,
before the police station.
Yes,
That is number 15 to due. Same hard, Mr. AW, connection same. It is submitted by Mr. Aman that the present accused petitioners are the parents, parents-in-law and the brother-in-law of the deceased, and they are no way related in the alleged offense. However, it is a fact that the victim committed suicide out of depression, and they are not the abettor of the said offense. However, they are all ready and willing to cooperate with the IO in further investigation of this case if they are granted with the privilege of interim prayers, in privilege of prayers. Question. Next para, Mr. Kaushik, the learned additional PP submitted in this regard that as per the statement of the victim, all the accused petitioners were inflicted mental and physical torture on her and also demanded dowry to the victim and to the victim for which she took such step. However, it is submitted by Mr. Kaushik that the statement of all three petitioners are also available in the case diary. And they appeared before the IO and their statements were recorded accordingly. Next, considering the submission made by the learned counsel for the both sides, and also considering the fact of availability of the petitioner's statement in the case diary, it is seen that they were already cooperated in the investigation of this case, and thus their custodial interrogation may not be necessary for the purpose of investigation. It will fit case military accordingly extended privilege of pre-arrestment, and there may be some conditions abide by all these conditions appear. No, we are putting some conditions now. We are putting some conditions. So abide by all the conditions appear as and when your cooperation will be required.
My lord.
Will pass the condition. Otherwise, we are granted with the privilege of pre-arrestment. Disposed of.
Grateful.
Yes.
16 search it submitted.
Whether he was on interim, in which item you are?
16 Lordship.
16. Your search sheet has already been submitted. You are on interim.
Lordship.
Item number 16. Yes, CS number 197/24. 3112. 24. Interim B, penalty. We are extending your interim till 15 days.
Obliged.
18.
Yes.
Lordship, pre-arrest bail petition, Lordship.
Yes.
In this case, petitioner is not the Elahan accused, Lordship, but his name was in the charge sheet. Lordship, kindly have a look at the Elahan case plan.
It's an NDPS case. As per my
And
idea,
there, along with the case day also you have to pay those.
yes, my lord, because my lord, and 28/3/25 is was fixed for appearance, my lord.
28/3. No, he is not appearing, I think.
He's not appearing, my lord.
Ah.
And another thing, my lord, I would like to place one judgment here because since it is an NDPS case, my lord. The NDPS case, my lord, and there is a judgment, my lord, anticipatory bail cannot be.
Lordship, but in this case, there is a favorable judgment also. Tufan Singh versus State of Tamil Nadu. In this case, paragraph 29 onward, Lordship.
But bouncing will come in case of arrest.
But it is in between, Lordship. And the Lordship kindly have a look at the judgment of the Tufan Singh, Lordship. Paragraph 29. May I read the paragraph 29, Lordship?
Well,
Let's
first
fix
of
it
all,
after Bihu, my lord. Then I will go.
if we are not,
Yes.
in a position to, and then it will be come after Bihu only.
No.
Okay.
Yes.
By that time, whether you're against you any summon issued or
Someone is.
summon issued. You make a prayer for time also
Lordship.
by the indemnity.
Yes, sir. In that law, Lanet Court below, Lordship, they are praying for time.
That was allowed.
That was
Yes, Kaushik, when it can be? After Bihu. So this is a scan copy only, and we can call for the present status report otherwise. Present status report for Kuwait, scan copy has already been received. Yes, Mr. Kaushik, when it can be called.
My lord, on after 24th, any date? Because it seems I look till 24th possibly. Occupied, my lord.
30 will do, 30.
all right.
19.
Here also we have received the case diary.
Okay, comparison is 13.
Is this charge sheeted one or not?
No,
Not.
no.
FIR is at page
13.
13.
Yes.
Yeah, otherwise CD received.
Just a second. Sir, বিলি করেছে। বিলি কি বলেছে?
Voice conference. 12.54. No, it is very. Small quantity of available.
তাহলে আমি খবর করিলাম। আচ্ছা যদি আর টু বহে আমি ফ্রি থাকি। আর যদি নর্মাল বহে না। If time permits, লেখা আছে। ওটাও ডিভিজন ইচ্ছা কৰিব, ডিভি কৰিব। who single বহিব, who ডিভি বহিব। And tomorrow is going also. Pressure হ'ব বেছি আছে। চাই লওঁ কি হয়। আমি ফ্ৰী থাকিম বাৰু এইখনত। Yes. That is on intermediate quantity.
She was arrested, then lordship, then released on bail. After arrest, released on bail. Case number, lordship, 17, that order I have annexed. There, lordship.
Initially, she was arrested.
No, lordship, the FIR name accused person arrested and recovered 12.54 grams. I'm not that person. I'm also named the FIR, but allegation against me that she got that heroin from me, and I am from Investigative.
The person from whom the recovery was made, she was arrested
And got
and
bail.
subsequently she got bail.
Yes.
And now you are the person from whom she got the.
She got.
Acha.
And Lordship, in the bail order, Lordship, I have attached the bail order of that lady, Lordship. It is observed that total amount weight is 2.88 grams. Without that container. Yes, which is a small quantity. And observation is made on 19. On page number 19, Lordship. Referred several cases. Lordship, this is a valuable section that falls under 221A.
It is considered a small quantity.
Yes. It is discussed in the page 18 and page 19. Perceive that it is primarily versus the state of Assam bail application of this Honorable High Court Lordship. That as a seizure pertains to, in that case, Lordship, 3.58 grams of heroin, which is bailable offense under section 21A of the NDPS Act, Definition of Release on Bail. In that matter, Lordship, is observed. Is mentioned it here in page number 19. Lordship.
Now, on one hand, you are saying it's a bailable offense. On the other hand, you are seeking anticipatory. I don't know what is this. If it is suppose as per you, if it is a bailable offense, then obviously you no need to come for anticipatory.
Depends, not mandatory. In any case, my lord, I know my lord, my learned opinion, perhaps not referring the judgment. That judgment was by one of our honorable judge of this court, my lord. Here, that small quantity is available. But there are different judgments where specifically said that my lord, small quantity is not available because there is a non-obstructive clause in section 37. And in Riya Chakraborty case, that sound case, my lord. There, Bombay High Court said that this is non-bailable, small quantity.
No, obviously, if you go by the, I don't know, there were some judgments passed by some high courts, and earlier it was not passed by this high court, but subsequently there may be 2-3 judgments where the it's considered the bailable. But if you go by the statute itself, it's a non-bailable offense. And there is no anything that is a bailable offense. That is not there.
He was hearing the matter that was subsequently released due to his superannuation matter. But subsequently, that matter is still pending, to my knowledge, in our High Court. And the Supreme Court also, the matter is pending. I don't know about the reference number, but that is pending. Because there are different views of the different High Courts. But most of the High Courts
Some
says
high
that,
courts, yes.
most of the High Courts says that it is non-bailable.
But it's, if you see my view, it's non-bailable.
It's non-bailable.
It's not a bailable offense.
Yes.
Because maybe small quantity, whatever, well, otherwise, but it's not bailable. Anyway, what is there in the
Otherwise,
FIR?
he is the main supplier. He gave the packet to the lady who was arrested. From her statement, his implication. Yeah. And he's the main dealer, basically. The FSL report is still not here. FSL
FSL report is
awaiting.
awaiting. Had Mr. H.S. Bora, the learned counsel for the petition. Also had Mr. R.R. Kaushik, the learned additional PP, appearing on behalf of state respondent. This is an application, so and so, and section so and so. City receipt. It is submitted by Mr. Bora, the learned counsel for the petition, that nothing has been seized from the person of the present accused petitioner, and he has been falsely implicated in this case. However, it is a fact that his name is also mentioned in the FIR, but he is nowhere related in the alleged offense. Further, he submitted that the bail prayer of one of the co-accused who was arrested in connection with this case is already granted bail by the learned trial court below. Right. Order dated 14/10/2024, passed in 24 by the Special Judge NDPS Lakhimpur, not Lakhimpur, considering it to be a bailable offence. He's further submitted that the accused petitioner is a permanent resident of his address locality and he will cooperate the IO in further investigation of this case if his prayer for pre-arrest bail is considered. Mr. Kaushik, the learned additional PP submitted in this regard that there were sufficient materials so far collected by the IO against the present petitioner, and he is the main kingpin of the entire case, wherein he used to supply the contraband for trafficking and he is the trafficking, and thus his custodial interrogation may be required for the interest of the proper investigation. Further, he submitted that that though it is a but it was considered initially it was registered under 21B.
It's still registered under 21B.
Already is registered under section 21B oblique 29 of NDPS Act. Though the learned special judge, while passing the order, had observed it as a small quantity without the container. Accordingly, he raised objection and submitted that the present case non-bailable offence what 22B, though it is also, however, even if it is considered to be a small quantity, in that case also the case is non-bailable as per the statute. Next paragraph, considering the entire submitted made by learned counsel for both sides, materials available in the case diary and available in the case diary, I find that the custodial interrogation of the present accused petitioner may be required to unearth some more facts of this case and to name the other culprits, if any. In view of this, the present petition stands disposed. Your petition stands rejected.
Timing 3.
Yes. Time being 3 years ago. They were asked, they provided us this one only. It's a neither I mean it's not a certificate copy also. So how can we accept this one? So we asked that if you can give us the 10 copy, but till now they are not appearing. Let it be adjourned then. After review, immediately after review for you. Petitioners remain absent. On call. Please the matter accordingly immediately after review. Single bench. Maybe by 2 it matters. Division bench we have a division bench, but with Justice Pathak, he had 1 DV, then again single, then again DV. Yes. On Saturday, now we are not in a mood of impact, but we have to.
Saturday actually we had to do our